Hi, good day. I'm Pearl Skelterma, the CEO of Atani Estates, and we are still on the topic of conduct rules. Where do you find those? Conduct rules are contained in Annexure 2 to the Sectional Title Schemes Management Act, Act 8 of 2011. In a previous clip, I've already explained the process to follow if you want to change, amend, or add to these rules. Who approves it? The Chief Ombudsman does at CSOS, no longer the deeds officers. Ladies and gentlemen, I sometimes frown when scheme executives approach me to say, we want to change our rules, we want a no-pet scheme. Be very careful, be very cautious. Why? Because if you do submit a complaint, either to the courts or to CSAS, it will be ruled on a basis of whether the rule is reasonable or not. And that's a very difficult one. You then have a third party deciding in your scheme what should be considered reasonable or not. Let's go to the content of these rules. An occupier or owner, first and foremost, may not keep any pets. Not a cat, not a dog, not a reptile, not a bird, unless they've obtained the prior written approval from trustees. What does that rule further say? If they do apply, the trustees or scheme executives may not withhold permission unreasonably. Once again, a very difficult one. Who decides what is reasonable or not? Secondly, the rule says that a person, occupier or owner, who is visually or hearing impaired and have to rely on a dog for guidance or assistance does not need the approval of trustees. They may bring a dog onto the premises without obtaining the necessary approval. Furthermore, subsection 3 of the first rule says, trustees may determine the rules and regulations and conditions on keeping of pets. So in other words, if you receive an application for keeping a Rottweiler, what do? You need to consider, how big is this dog? Would it be reasonable to keep a pet of that size in a 5 by 2 square garden? No, it would not. So think carefully. Determine in your rules what size dogs, how many dogs. Furthermore, cats, they roam. There's nothing you can do about it. So one of your rules should say you could keep a pet, but they have to be contained within the confines of your section. Whether that's possible or not, I don't know. We get complaints on a daily basis to say that that's not the case. The fourth part is almost the most important. If an owner or occupier does not abide by the rules or regulations determined by the trustees or scheme executives, they may withdraw their permission and ask you to get rid of your pet. And this is where the problem starts. So if you refuse, if the occupier or owner refuse to get rid of their pets, what is the process to follow? It could either be legal action, obtaining the services of an attorney to say, here are all the letters of complaints, they just don't want to listen to the rules, get a court order and force them to get rid of their pets. Or alternatively, lodge a complaint with CSOS, with the Community Schemes Ombudsman Service. There will first take place a conciliation to see whether they could reach a win-win situation with both parties. If that cannot be established, the matter would be escalated to adjudication, which is a much more formal process, and the ruling will determine whether this occupant, owner or tenant, needs to get rid of their pets. But as I've mentioned before, it will be based on whether the rule is reasonable or not. Ladies and gentlemen, if you want to find out more, we provide an online training course that would give you all the information you require. Please go to our website, have a look at this, and hope to speak to you soon.